Welcome to Notes to My Legal Self. The future belongs to builders. Together, we explore topics of interest to legal innovators. Know someone who'd make a great guest? Let us know. Self-nominations are encouraged. They're an act of courage. Want to get the most from this conversation? Ask questions, comment, like, follow, say hello. In short, engage. Lastly, have fun. Shaping the future of law requires significant effort, but finding joy in the process is essential. Let's begin. Here's your host, Olga Mack.
Well, hello, everyone, and welcome to Notes to My Legal Self. The future belongs to builders. And today I have an amazing guest. She is a builder. She's building something truly remarkable and amazing. She's an advocate for access to justice, and I am personally a big fan, practically a groupie. And without further ado, Sonja, welcome to Notes to My Legal Self. Please introduce yourself for those folks who have not met you yet.
Olga, it's great to be with you. Thanks for having me. I am Sonja Ebron, founder at Courtroom 5. We offer an online litigation support platform for people representing themselves in court.
I love that. So you have a very rich background. You've done quite a few things. How did you get up in the morning and decide to do that?
I'm trying to keep up with you, Olga. You have certainly set a standard for getting things done. So for me, I'm not a lawyer. I'm actually an engineer. I got into the legal space because I got sued and really felt shut out of the process. Couldn't figure out the legalese and the procedures necessary to represent myself, and saw lots of other people, predominantly Black and brown people, women as well, who were in a similar situation, and just realized that something had to be done about it.
I love that. So you have an engineering background. What were you doing before you decided to surround yourself by legal professionals?
I was a college professor. I had studied, power lines and transmission lines and, heavy equipment for delivering electricity to people and communities. And so I was teaching engineers when this all happened. So very well educated, but didn't know anything about the law very much. And so, just found myself having to learn very quickly how to present a case in court and get a hearing. It was
Oh,
difficult. I got my butt kicked. Lawyers, you guys go to graduate school for this, right? It's not something for lay people to just pick up over a weekend. And so very difficult situation, something that happened unfortunately more than once. And so just realized I was making progress on being able to represent myself, but a lot of that had to do with being overeducated. And again, I saw so many people though who just had no clue where to start, how to figure out even what to learn if they had the capacity. And so I just wanted to do something about that.
I love that. So from teaching some complicated systems to other complicated system. I mean, I think
Yep.
complicated systems are your specialty. So I think that's the common theme here. Um, you mentioned you personally had to be involved in a couple of lawsuits. Was it in small claims courts or was it actually in federal, state, sort of regular courts?
I have not been in federal court, but fairly serious stuff in state courts, a variety of them. And so, without getting into details, just having to figure out, the long flow of real litigation. You in small claims court, we all know about Judge Judy. You get a complaint, there's an answer, you go to see the judge. Judge asks a few questions and makes a decision, hopefully based on the law, and you're out of there. Real litigation, as most lawyers know, is a much more complicated process. There are questions you don't even know to ask, right? Language that may mean one thing in common sense, but quite another thing in the law. And so, it's just a really stiff learning curve.
So you were going from throughout the whole process by yourself.
Yeah,
Wow,
yeah,
wow,
exactly.
wow. I would not want to do it by myself, and I'm a lawyer. You're very
Most people
courageous.
don't. Well, it's not a question of courage. Most people, if you can afford to hire a lawyer, would certainly do that. In fact, I've had an occasion of hiring a lawyer when I got into this sort of situation, but the bills start stacking up pretty quick, right? The average rate for a lawyer today is well over $300. That's average, right? Courtroom 5 has some pretty expensive lawyers. I think our lawyers are billing at over $700 right now. Worth every penny. You wouldn't want to be without them, but it's certainly something that I, as an individual, couldn't couldn't afford, even the average rate. And so, we unfortunately live in a society where 40% of people can't find $400 in an emergency, right? They're not going to pay $300-400 hourly rates to be represented in court. And so while most people in the situation I faced would certainly hire a lawyer, the reality is that most of us simply can't. And so having to represent yourself is a burden that we just have to shoulder because we don't have an option.
I like Wandana's description of you. I'm picking that up, Wanda. It's pretty clear that Sonia is a force, and that's why she's here. I love that. That's exactly what I love.
I
I'm
appreciate
gonna.
Wanda as well. Thank you.
I guess I'll ask you, how did it make you feel to go through that process? It's a process that I would not want to choose for myself, even with the lawyer. Definitely without a lawyer, you would have to drag me through it because I have an
Yeah.
educated guess of what's involved. But you actually have been through the process and it sounds like by yourself. Without, I don't want to go into details. What I'm trying to get is, was it scary? Was it complicated? Which parts were frustrating? As a user of this not so friendly system, what are the top three things that stuck out that inspired you to start Courtroom 5?
I think most of us go into this situation with decades of Judge Judy's court in mind, or Judge Joe Brown, or the TV court shows. And so I guess the initial feeling is, I'm going to go in, and I'm going to collect my evidence, and I'm going to go and tell the judge what happened, and I'm going to get a judgment in my favor. And so, there's some exhilaration around it when you think you've got a good case. That's the first thing. You've got a new challenge, and you sort of take it on, but you quickly get your hopes and aspirations dashed when you're faced with real civil procedure. I guess the predominant feeling for me, and I know from the experience of our customers, is, the old story about being the skinny kid on the beach and the big muscular guy walks by and kicks sand in his face. It's sort of that way. You really can't do anything about it. Again, you're talking about lay people with pretty much Judge Judy in mind, faced with someone who's gone to graduate school for this, someone who's been practicing in your specific type of claim for many years, and someone who practices in a specific court, so knows all the people, knows the judge, knows the clerks, knows how to navigate the local rules. And so you're at a tremendous disadvantage, and you realize that. If you're lucky, you realize that pretty quickly and maybe can do something about it. But it's really just feeling overwhelmed and beat up and humiliated. Those are the primary feelings that come to somebody in this situation.
Yeah, the skinny and the muscular guy. I love that. That's an interesting way to look at it. Definitely picks up some of the themes. You mentioned slightly, and I do want to dig into it. There is a sort of correlation with race, gender,
Yeah,
I would say socioeconomic
true.
status,
That's
immigration
right.
status. That has been I've had some adventures with courts, including being the DA. So I know who's represented and who's not. And there is a massive correlation, and you can't ignore it if you what you want is justice. So I'm gonna ask you to sort of maybe reflect on your observation of what's happening and how that what it practically means when we talk about access to justice.
Yeah, yeah. We can go so many places with that question, Olga. You remind me, I had a conversation with a group of environmental lawyers out in Alaska last year. And one of they learned I was an engineer and not a lawyer. It was a legal conference. And so we got into a conversation about the differences between scientists and lawyers. And one of the things that sort of rose to the top for me was that lawyers get a great education on power. I learned power systems, electrical power systems, right? But lawyers get a really good education on ways to use power. And when you're talking about litigation, you're talking about an adversarial system where, as it's designed, one party's going to win, another party's going to lose. We know most cases settle, but nonetheless, that's the way it's set up, as adversarial. And so, when you have a person with no legal background and opposed by a party that's represented by, again, someone who's gone to graduate school for this, the power imbalance is really, really obvious. And ethically, for a lawyer, your job is not to the democracy, not to our society, but to your client. Your ethical responsibility is to win by any means, reasonable means necessary. Right? You're not going to kill anybody, hopefully not steal, that sort of thing. But your job is to win, and your job is not to take care of the poor, unrepresented party on the other side. And that power imbalance really shows up in the access to justice crisis. Again, most people would hire a lawyer for this very difficult work if they could, but they can't. And the power imbalance makes this a crisis because right now, more than 3 of every 4 people in court are there without a lawyer. And by and large, their opponents are some government entity or a corporation. These are entities that have to be represented by counsel, and so that imbalance really plays out in our courts day after day after day. And I don't think you'll see that quite as vividly in any other branch of government. And so that's really what the access to justice crisis means for me. It is a violation of our understanding of what a democracy is supposed to be about. We are, in particular, and I can go on at length here, so shut me down. But we're supposed to have access to all 3 branches of our government, in particular to the courts, because that's where we have a right to petition government directly. The individual right to petition government resides there, and yet the vast majority of us are shut out of that process. And so that's the way I think about access to justice.
You articulated a lot of things. All of them are absolutely true. I can tell you two things that are interesting is sort of the parallel between engineering and law, which is something I deal a lot with as a tech lawyer from a different side, the complicated systems, the one that you articulated around power. You need to handle power, whether it's electricity power or power, as a professional, educated, dressed appropriately with tools that are necessary. Both could be lethal and needs to be handled correctly. I think that's a really important parallel in this conversation. We have Aaron who talks about pro se litigants on TCPA, which is the Telephone Consumer Protection Act. This is when people call you without authorization and violate all kinds of laws. Most states have those laws. It's one thing to do this in the small claims court that is designed to be without lawyers, which most folks struggle with to begin with. You, Sonia, actually talk about something else, entirely when you go to state court and dealing with the government lawyer or a corporate lawyer. That's a very different power dynamic. And I'm not sure which one is more powerful, because technically when you deal with state or federal lawyer, you basically have the resources of the entire state or federal government behind them, so that's even more powerful. Interesting that you've observed this imbalance and comment sort of back to democracy and our rights, constitutional rights. So is it your view that we're not quite living to those ideals in the
I think,
Constitution?
oh yeah, I mean, I think it's clear. I fight cynicism on a daily basis. I have to, I'm always aware that we've got a difficult history in this country, and it, has not always met its aspirations, certainly around democracy and including everybody who's governed, in that democracy. And so our courts, as they're represented today, certainly, share those beginnings and haven't, in my opinion, made a great deal of progress in terms of including people. They're very, very technical procedures, at least outside of small claims, some of the summary proceedings as well. If you're involved in real litigation, the average layman has just really no chance, right? When you're faced with a represented party, as most are. So yeah, that's where I see the access to justice crisis. Again, if we don't have fair access to justice, then we don't really have the rule of law in this country. And if we don't have the rule of law, we can't have a democracy. And so access to justice, in my mind, drives a straight line to democracy, or the lack of it.
Well, you have Nick saying hello. Sonia, you
Hey,
have quite a fan base. Folks are proud of the work you're doing. I'm really excited about this conversation. I do want to dive deeper into sort of the actual obstacles. I think one of the things
yeah,
that you identified is this technical part of it, right? Like you actually have
yeah,
to be enough of a technician to navigate your courtroom. The other thing you identified is this training to deal with power. You actually like judge is sort of an
yeah.
epitome of power. You have folks representing the power of the government. That's an epitome of power. Those are the two things I identified. Is there anything else like that you can sort of identify as an obstacle for Olga to show up and get justice?
Yeah. Yeah, those are two key issues. There's the technical, requirements of real litigation. There's protecting yourself as well as you can from the power imbalance, and the lawyer's ethical responsibility to represent his or her client and not be fair to you. But the third part is the use of litigation strategically, right? Which lawyers know to use, but most lay people just have a misapprehension or yeah, I would call it that, a misapprehension of the use of litigation strategy or the fact that such a thing even exists. So we spend time, educating our consumers on having an end game in mind that's realistic. What do you want, and developing a game plan to reach that doesn't necessarily involve the technical aspects of various filings. And so those are the three issues that we tackle at Courtroom 5.
So actually, the strategy part is actually very interesting. So tell me what you
Yeah,
mean by that. Like
yeah,
the end game, kind of what are you driving towards? But this is where lawyers actually a lot of what lawyers does is not seen in the courtroom and is not seen on TV. This
yeah.
is sort of client attorney client relationship where you ask questions to really ascertain what's definition of win and various ways to get there. And depending on a timeline, budget, I don't know, stamina, whatever, you will end up going a certain way. Tell me a little bit more about Courtroom 5, how it works. And then how do
Mhm.
you actually can get to that strategy? Because that's actually mission critical. That is like 80% of what a lawyer does.
That's right. I agree with you, and should be, more considered by pro se litigants as well. So let's take the three challenges separately here. First, there are the technical aspects, and so most lay people don't understand the difference between what they're involved in and Judge Judy's court. Right? That there's going to be a long flow of filings and court appearances and meetings, between a complaint and the actual resolution of the case. And so we have to help people understand first what needs to be filed based on where they are in the moment. People come to Courtroom 5 preparing to sue somebody or having already received a final judgment and thinking about an appeal and everywhere in between. So we first work to locate folks based on the procedural history and then point them to some options they should reasonably consider at that time. Again, just providing information. We don't advise people on what to do, but we, have them understand some reasonable options based on where they are in the case. That's the first thing. Once they've made a decision on what to file or serve, we help them make that filing or document effective. So there is claims and defenses analysis. If you tell me you're handling a negligence claim in Kansas, we can tell you automatically what Kansas requires, be proven, what the elements of that claim are. Same with defenses. And so we'll help you associate the unique facts of your case with the legal elements. So you can sort of see the case from a judge's perspective. After you do that, you typically come out with a legal position on the filing or the procedure that you're involved in. We'll help you find case law, statutes, rules of procedure, whatever is necessary to support your legal position. And then thirdly, we'll help you actually assemble the document in a format that is helpful for the judge in your case, something they're used to seeing. And so those are the technical aspects. We also offer, human services, right? You can get occasionally limited scope services with a real lawyer handling your type of claim in your jurisdiction. More often, we have paralegals who provide coaching services to just help people manage that very difficult work. We have strategy workshops. We'll help you organize your discovery, some other types of services that we offer there. So that's Courtroom 5. That's the first thing. Let me stop there before we move on to the second challenge.
No, let's definitely move to the second challenge, but I do want to highlight that there's a lot of fans out there who wanna clone you because you're doing so much good. So I don't know how much inspiration and help you need from the community, but it is there. So with that in mind, let's do number two.
Yeah, and so number 2, and again, remind me, it's the middle of the day here. What was number 2? Let me, remember.
Well, we discussed three items. We talked about the power
Yeah,
imbalance, the technical things that I think
the
you
power
discussed, and,
imbalance.
and
That's what it is.
strategy.
Yeah.
Um,
The power imbalance. That's it. And so again, we help our customers at Courtroom 5 understand the power imbalance, that they are up against somebody who is serious about essentially shutting them out of the process if they can't stand up. This adversarial system of ours is designed for two represented parties, right? And so if you're going in without representation, you're at a disadvantage. And so we highlight for them sort of the playbook that we've identified over time that lawyers have when they're dealing with pro se litigants, right? And there's some certain traps that are going to be set for pro se litigants. And so we help our folks just avoid those things to level the playing field. Common example, if you fight well enough, at some point in the case, there's going to be an important filing by your opponent, and you may not get served as a pro se litigant, right? You literally will not get it in the mail, okay? And so we make sure that our members have designated an email address for service or have registered with the e-filing portal if that's available in their state. We make sure that they are able to be served electronically so that they never miss anything. Just take that issue off the board.
yeah, no, it's,
We
it's an important
advise,
issue. If you don't know what's going on,
right?
you don't have a shot to defend yourself. Let alone, I'm not even talking about substance. If you're not there, you're not there.
Yep. That's exactly right. There are dozens of those sorts of, tricks and traps that we help our members avoid. You want to try to take a court reporter when you have to go to court. A lawyer doesn't necessarily have to do that. It's an additional expense for our customers, but we have seen over and over and over the presence of a court reporter give you a much more professional day in court when you're there without a lawyer. And so, again, dozens of little tricks like that to level the playing field when you're in court without a lawyer.
Okay, okay, this is great. Anything you guys do sort of on this strategy? Kind of what is,
Yeah.
or is it sort of part of the playbook? How do you approach it as this sort of as an item? Because that's a big chunk.
It is. It is. Strategy is really, really important. So there are two ways that we think about it, and we help to educate folks on. First, what is the purpose of your litigation? Like, why are you in court? Many people have just been sued, and they have to defend themselves because they can't take a default. They can't just walk away from the claim against them, or sometimes there are kids involved. I mean, there's a variety of circumstances, and so but we always ask people to ask themselves, why are you fighting this? What do you want as the ideal outcome or reasonable outcome of the litigation? You want to think about that strategically. And then secondly, how are you going to reach that goal? Let's have a game plan. Don't, sit on the back foot and wait for things to be filed that you then have to react to. Be proactive about it. We can educate you on the flow of litigation and what typically happens between a complaint and maybe an appeal. But think about it, we educate people on some of the options and help them develop a game plan of their own so that they're not simply sitting and waiting for things to be served on them and then having to quickly react to that. So, we think about those things and think about strategy in both those ways.
And is it
And one other thing about strategy, just a quick example. If you are in a foreclosure lawsuit, for instance, right? Your mortgagee is trying to kick you out of your home for whatever reasons there are. Litigation should take a long time and does if it is performed properly. Right? If you don't know what you're doing in a foreclosure lawsuit, you're probably going to lose your home in 3-4 months or so, right? It may be that you didn't pay your mortgage, but you can actually use the litigation process strategically to stay in your home for longer than maybe you deserve by the rules of law. Okay. And so, fair, not fair, we don't get into those issues. We just help our customers understand the value of the litigation process for meeting some strategic goals.
and I'm curious, in that strategy, is it sort of a one-on-one you have lawyers available to help at various rates, or is this sort of a productized, plug booktized? I just made up a
Yeah.
word. I'm known for making up words. This is what you do when English is your second
Yeah.
language. You make up words all the time.
That's
Um,
it. That's it.
so is that kind of a standard procedure, like a playbook
Yeah.
where you can, you know that you have clients with custody issues, with
Yep.
foreclosure issues, whatever, and in that kind of litigation, you have to make, five strategic decisions, and
Mhm.
depending on those decisions, like this is the door you open. Is that how you guys
Yeah.
do it? Like, tell me how that works. I'm just curious.
Again, both. I mean, we have enough examples like the one I shared to just educate people, awaken them, if you will, to the use of litigation strategically, right? Or to meet specific goals that they might have. Sometimes just letting them know, yes, you can use litigation, other than what you've seen on television. Sometimes just letting them know, and they're off to the races and can do it themselves. But we share those sorts of situations that come up over and over again where people have used litigation to meet some out of court goals. But additionally, there are opportunities to meet one on one and to flesh out specific strategies if folks want to take that on.
I love that. By the way, I got some support for plug book ties. Making up words. I appreciate the community being there for me too. Thank you so much.
That's right.
That's what I need. Make up words. I need that.
Let me just say on that point, I had an opportunity recently to see I think it's one of your first TED Talks, Olga, where you talked about legalese and the need to learn the legal language, right? And, productizing it in graphical form, if you will, to make it easier to understand. Really enjoyed that. And so I know you've done a lot of that work
Yeah,
with
yeah. No, I
LexisNexis
mean,
and,
for
and
me, I
before.
navigated system not on the litigations, but on the immigration side.
Yeah.
And my English was not good for a long time. My parents were convinced that it was good much sooner than it actually was good. So, and I had a pleasure and a burden explaining this dense stuff that we were receiving in mail from both
Yeah.
private and public sources. And my dad just was convinced that if I try a little harder, I get it. And then even if I get it, explaining it to him, because my parents are engineers too, they
Hmm.
were not really following a lot of that. So I actually use a lot of pictures. It turns out engineers and normal humans respond to circles and boxes much more than they
That's
respond to
right.
walls of text. So every time something would come in, eventually I get a sort of understanding of what that means. And I like to draw. He seems to be getting pictures. So we would just sit there and draw boxes, and that's kind of collectively, he was the strategist, I was the speaker, and the two of us would take on any system. So
Yeah.
that stuff
Yeah.
works. The playbook stuff works.
It's really an important topic. I mean, I spend some time just following the plain language movement in legal, and wish it were moving much faster than it is. But can you imagine being able to understand some of these complicated legal procedures, litigation procedures, graphically? I mean, it's a really important mode of communication and training. So I would like to see more of that work
Yeah,
in the
speaking
law.
speaking human is totally a thing. Connecting with
Yeah,
your human beings and being with them on the same page. I mean, heck, that's what we all talk about in business and
that's right.
academia. Why not law include on this journey? And Christopher Guy Thompson very much agrees with that too. I believe we have a lot of approval here. We're coming to the end. I do want to talk a little bit about technology, because
Sure.
technology, I think, has this opportunity. When you disrupt the system, you can also have an opportunity to rethink the system. It's actually not that different from engineering. When the system doesn't work
Yeah,
and blows up, you don't have to,
yeah,
you can say, oh, how do I rebuild the same thing? Or you can say, heck, that was a bad design. It blew up. Let's do something better. And I think technology really kind of gives you an opportunity to be like, oh, this is kind of crumbling, about to blow up, probably big time. Let's like put our efforts, put up fire. And then when we do it again, let's not rebuild, let's reconstruct, which is very
yeah.
different. This is where you say, okay, what have we learned? How can we do this better? So my question to you, how can technology do justice better?
Oh my, we could be here all day, Olga. I love that question. We've heard a lot about AI lately, and we're going to hear lots more about it. I mean, it is growing exponentially. I think it's one of the most exciting things I've seen, certainly in my work in the law. You may know, way back in the day, I wrote one of the first peer-reviewed technical articles on AI and power systems, electric power systems. And so I've been sort of tracking the growth of AI over the decades here, and I'm really, really excited about the potential that it has for improving access to justice. And so we've released a couple of features at Courtroom 5, embedding AI agents into the flow. We've got four more slated for release in the next few weeks. But I think the value of it is in actually having communications with people struggling to learn something new is it's priceless in terms of giving people the leg up that we've been struggling to do for some years now at Courtroom 5. I think it is going to be transformative. People are already using it. Regular people, not just lawyers, are already using it to sort of knock down the courthouse doors and get at least at the beginning of a process started. When you get into the weeds, there are challenges we know about in AI, but then there are many more challenges of using it
Look, I mean,
without
the reality
guardrails.
is I would rather like 10-20% of people deal with hallucination problems than 100 or 95% of people being locked out of the
Right?
system. I mean,
Yeah.
that's a trade-off I would do anytime without even like missing a heartbeat.
Well, the challenge there is that getting a legal document done and to start a procedure is it's great, it's wonderful. I would not want to stop anybody from doing that, but that doesn't really solve the problem of access to justice. If you get Chat GPT to write your answer to a complaint, you've got a couple challenges here. First, was that the right thing to do at that time, right? A lawyer doesn't respond to a complaint with an answer. There's some things you do, right, in between. And so if the layperson doesn't know what to file, ChatGPT isn't going to be a whole lot of help. You pretty much dig your grave with that. The second thing, though, particularly in state courts, is that decisions, they're going to be motions and motions and motions and motions. Decisions on those motions are what set the table for trial for you. And those decisions often occur not as a result of the filing, but as a result of the oral argument in court. And so if you just file something and you show up to court, nobody's going to let you just sit there and read what you filed. You've got to argue. You've got to battle opposing counsel, which means you have to understand, what it is that you file in order to get the proper order, an order, that lets you move forward. And so Chat GPT is wonderful, but it needs some assistance
Well,
that hopefully
one
we're
of the
building at Courtroom
challenges,
5.
Sonia, and you tell me if I'm wrong, one of the
Yeah,
challenges is that laws are actually not very public. I mean, sure, the
right.
basic
Yeah,
statutes may be,
yeah,
but decisions, treatises,
yep,
hey, liens, like there's
yep.
what I call shades of gray in public. There's things that are definitely available and there's things that are private. And a vast majority of things you need to send a courier. It's not those
Right.
proceedings that are public, but the records are not available online. Like we do have sunshine laws that require government and public proceedings to be online, and we meet that requirement in many ways, but not necessarily by putting it available on internet. And
Hmm.
therefore, if
Right.
it's not available, it's behind firewalls, or you have to send a courier.
You got it.
You cannot
You
train
got it.
ChatGPT on that. So if ChatGPT actually ingested everything that should be publicly available, I think it would be a better tool, don't you think?
Again, there's the guidance on what to do, right? A tool, you can use a hammer to put a nail in a wall or to clobber somebody over the head, right? And anything in between. You have to know what to do before you use the tool to do it. That's the key, right? So you have to be educated on the entire domain, on the entire process before you can use these technologies in the proper way. Otherwise, you're just digging a hole. That's the danger of it, particularly for lay people involved in this kind of complex work.
Yeah. Well, and technology could be better if it's actually more properly trained, not just
Right.
what's available, but what should be available. I do maybe we're coming to the end. I do want to talk about regulatory landscape. As you learn pretty quickly, law is a regulated monopoly.
Yeah.
There are barriers to entry, which partially leads to access to justice problem, despite all the good intentions that you read. When you go to any bar website, it has really lofty goals, but we know the results. The results are pretty clear. Access to justice problem, and heck, yes, for people with who do not have enough money, but frankly, we all have access to justice because law does not pick human, and we're not included on that journey. So I'm curious, what do you think needs to change for all of us, to be included on this journey called justice, for Lady Justice to stop being, let me use appropriate word, a snob, and for justice to be of service? What do you think needs to be happen on the regulatory side?
Right. The big threat or concern I'd say for organizations trying to help consumers is, UPL enforcement, right? Unauthorized practice of law enforcement. And it really stymies the innovation that we could otherwise do. We're always having to wonder, if I put this tool out there or this feature out there that might help my customers, what's the bar going to say, right? And Courtroom 5 is nationwide, so we've got 50 state bars to be in conversation with around some of these issues. It slows things down. We've all seen just over the decades, bar associations go after LegalZoom, after Avo. Most recently, I think it was Ticked, or that a traffic ticket enterprise in Florida, and many others. I mean, it's legion. Some of the folks on your show have had challenges with regulators. We've certainly had our conversations, as I'd say. It's expensive. It just slows down the innovation that we are all building towards. Courtroom 5 is one of the founding members of the Justice Technology Association. It's a trade organization for about 50 companies and nonprofits delivering legal tech to consumers, right? We call that justice tech. And all of us, by and large, have many of the same concerns regarding UPL. And I often think about, what the world would be like if those regulators would simply focus on preventing consumer harm, right? Rather than making sure this organization isn't, violating some obscure principle around the practice of law, which no bar association, no lawyer that I've ever heard is able to define, right? And so it is just a murky, messy, expensive process having to deal with the regulatory regime and do the best we can for our customers as well. So my fantasy would be to see a regulatory regime that, again, just work to ensure that consumers were not being harmed. I'd like to see JTA, the Justice Tech Association, grow, take on more members. We have very strong ethical guidelines, a code of ethics that we recommend to anybody working with consumers. There are ways to work with organizations like that, for regulators to work with organizations like that, to just make sure that consumers aren't being harmed. There are ways that we can do this without stymieing innovation.
Murky, messy, expensive. Wow, those sound like total compliments for lawyers. I love that. Yeah, UPL is a real challenge. It's funny. I have this conversation with many folks. It comes up a lot. It comes up a lot when I advise startups, even if they're not in actually justice tech, when they're in the future of law, like in on the periphery, or like insurance and stuff like that. Because at some point, like, when do you give legal advice, and there's a potential of litigation and stuff like that, and there's a fear. And while I haven't seen bars to go after many, you definitely don't want to be, a test case, because that's,
Right.
murky, messy, expensive.
Yes,
Not the
that's
things you
right.
want to do as a startup. I love those three words in this context. So absolutely, UPL is a challenge, and interesting. I'm just curious from your point of view as a founder who is not a lawyer. So your conversation with the bar, any bar, is bound to be threatening by definition. Just by definition. I'm curious. How do you feel about all that?
And I have to do it as the CEO of the company. I personally don't talk to regulators, we have lawyers for that. That's, there's a whole industry of lawyers that do regulatory work. And so we rely on their counsel and, and guidance to sort of mitigate and traverse those sorts of issues. But again, I think there are analogs in other industries, whether it's health or transportation, other places that have similar regulatory regimes, and they've been able to navigate some of these issues. I would like to see legal regulators borrow more from those industries that have not as sharply stymied the process of innovation.
Okay. Okay. I think we've come to the end. Not necessarily the most optimistic note, but then heck, the state of affairs is not all that optimistic. I mean, the arch of history is bending toward the you know right direction, but it just takes a little too long, and it may not happen in our lifetime, and that's what I find super depressing. But it's just not bending fast enough. What is the one takeaway you want to leave folks who joined, a lot of folks who support you and really wants to see justice tech show up and really help, everyone to have a better relationship with law? And thank you so much for joining. I thoroughly enjoyed this conversation and would love to hear the one takeaway for us to have better relationship with law.
I would just say, as I said earlier, battle cynicism on a daily, but I end each day very optimistic about where we're heading on the access to justice front. I work with consumers, my company does, all day long, and we know that we're putting the tools they need in their hands to be able to get the access to justice that they need. Justice isn't guaranteed, but access can be. And so, I think we're certainly doing the work. I know there's some other organizations coming down the pipe doing this work as well. There is great reason for optimism, and the impact of that, a better democracy, a more open democracy, I think should leave us all optimistic and feeling very positive about what's to come.
Well, justice may not be guaranteed, but access to it certainly helps. Well, with that in mind, Sonia, thank you so much. I've thoroughly enjoyed this conversation. I've had high expectations, and that you exceeded them. Thank you, community, for showing up and being part of the conversations. Clearly, there's a lot of enthusiasm for us to have a better relationship with law. Thank you so much for joining. I'll see you next time. Bye, everyone.
Thank you for stopping by. We hope you've enjoyed this episode of Notes to My Legal Self. The future belongs to builders. Know someone who'd make a great guest? Let us know. Self-nominations are encouraged. They're an act of courage. Keep in mind, the future of law is all lit up. Let's roll up our sleeves, innovate, build, and change the world of law together. See you soon.